Nobody plans to lose capacity. Nobody sits down and thinks, one day I might not be able to manage my own financial affairs, make decisions about my care, or tell the doctors what I want. But it does happen. A stroke, a diagnosis, an accident, and when it does, the question is not whether your family wants to help, it's whether they legally can. Most people assume they can, but the law does not work that way. Martin Lewis highlighted this on his ITV show. He asked his studio audience how many of them had a will, and around 60% raised their hands. Then he asked the same audience how many had a lasting power of attorney, and it dropped to around 20%. Now that gap is the problem, and today we're going to close it. I'm Jim from Elm Legal Services, and this is your guide to lasting powers of attorney. An LPA, three letters that most people overlook and that families often wish they hadn't. So let's break down exactly what it is. A lasting power of attorney, or LPA, is a legal document that lets you appoint someone you trust to make decisions on your behalf if you ever lose the mental capacity to make it yourself. That could be through dementia, a stroke, a serious accident, or any number of other circumstances. And as Martin Lewis pointed out on that show, losing capacity doesn't just happen to the elderly. He mentioned a message from a man called Alan, whose wife was involved in a devastating car accident at 33. She sustained a severe brain injury. No LPA was in place, and while Alan was dealing with grief, 3 kids and a life falling apart, he had to apply to the Court of Protection for deputyship, a court process, thousands of pounds, months of waiting. His message was simple. It's never too early to get an LPA in place. Now, a lot of people hear this and think, I already have a will, so I'm covered. That's one of the most common misconceptions we come across, and it's worth clearing it up right now. Most people assume a will covers everything. Well, it doesn't. A will only comes into effect after you have passed away. It has zero legal force while you are alive. An LPA, on the other hand, only applies while you are alive. They are not alternatives, they cover completely different situations. And without both in place, your estate plan has a serious gap in it. Think about it this way. You spend time and money making sure your assets go to the right people when you pass away. But if you lose capacity before you pass away and there's no LPA in place, those same assets could be frozen. Your family may not be able to access your bank accounts. They may not be able to pay for your care. They may not be able to manage your property, your investments, your business, or anything else tied to your estate. A will protects what you leave behind. An LPA protects everything while you're still here. So what actually happens if someone loses capacity and there is no LPA in place? And this is where things get really difficult really quickly. Your family faces a process called deputyship. And in England and Wales, this means applying to the Court of Protection. It is not straightforward, it is not quick, and it is not cheap. Families can face costs running into thousands of pounds and waiting periods of many months at a point where they are already under an enormous strain. When Martin Lewis covered deputyship on his show, the message from legal specialists was clear. It is a process families should do everything they can to avoid. An LPA exists so your family never has to go through that. With that in mind, let's look at what an LPA actually covers, because there are in fact 2 distinct types, and they protect very different things. The first is a Property and Financial Affairs LPA. This covers managing bank accounts, paying bills, and dealing with property and investments. It can be used even before you lose capacity if you choose to allow that. The second, however, is a Health and Welfare LPA, and this covers decisions about your medical treatment, your care, and where you live. It can only be used once you have lost capacity. Without the first, your finances and assets can become completely inaccessible at exactly the moment your family needs to act. Without the second, the people closest to you may have no legal say in decisions about your care or treatment. One protects what you own, the other protects how you are looked after. Together, they cover everything a will cannot. Once you've decided to put an LPA in place, one of the most important decisions you'll make is who to appoint to act for you. The person you appoint is called your attorney, and they must be someone you trust completely because they will be making decisions that affect your health, your finances, your life. You are not limited to one attorney. You can appoint more than one, and you can also name replacements in case your first choice is unable to act when the time comes. Life changes. People pass away, move away, or find themselves unable to take on the responsibility. Having that backup built in from the start is far simpler than trying to change things further down the line. You can also put guidance in the document itself. Instructions are binding. Things your attorney must do or must not do. Preferences are a little bit different. They tell your attorney what you would like without legally requiring them to follow every detail. Together, they give you control even when you can no longer exercise it directly. One thing your attorney cannot do is change your will. That is a boundary the law makes very clear. It's very easy for all of this to feel abstract, so let me share a story that brings it to life. On the Martha Lewis show, a woman called Janice talked about her aunt. They've been close since Janice was a child, and with no children of her own, her aunt had no one else who was going to step in and look after her interests. And after watching a program about LPAs, the two of them made the decision to get it sorted. And they did it while her aunt still had full mental capacity. Not long after, she was diagnosed with vascular dementia. But by then, the LPA was already registered, already in place, and because they had not waited, when the diagnosis came, Janice could speak to doctors, she could deal with the bank, the Housing Association, the Department for Work and Pensions. She could make sure her aunt's wishes were actually followed. All of it because the right document was already in place. Now, none of that would have been possible without the LPA. And the LPA would not have been possible after the diagnosis. That is the window. While someone has capacity, the door is open. Once they lose it, the door closes. Janice and her aunt did not wait, and that made all the difference. Most families are not that lucky, not because the situation is rare, but because they waited. So how do you actually go about getting an LPA? Here's what you need to know. In England and Wales, LPAs are registered with the Office of the Public Guardian, otherwise known as the OPG. The registration fee is currently £92 per document, so it's £184 if you're doing both types. Reductions and exemptions are available depending on your income and financial circumstances. You can apply yourself using the government's online service. Many people do, but tens of thousands of applications are rejected every year due to errors, and the rules are less forgiving than most people expect. Mistakes cannot be corrected with correction fluid. Every page must be included, signatures must be obtained in a specific order, and if anything is wrong, the application comes back. You start again. And while you're waiting, nothing is in place. For most people, getting professional help is the sensible call. Not because the process is impossible, but because the cost of getting it wrong or of simply not having one at all is almost always higher than the cost of doing it properly in the first place. So if you have a will but no LPA, your estate plan is only half complete. If you have neither, now is the time to put both in place, not when something goes wrong, before it does. There are decent professionals out there who can help you with this. Find someone you trust. Have the conversation and get it sorted, whether that's with us or someone else. The important thing is that you take that first step. If you would like to speak with us, we offer a free, no obligation consultation, and we're happy to help however we can. The link is in the description. And if you found this helpful, please like the video, share it with someone who needs to hear it, and subscribe for clear guidance on modern estate planning. The more people who know about this, the more families we can help avoid a very difficult situation. And remember, a little planning today can make a big difference tomorrow. So until the next time then, stay safe, stay informed, and stay tuned.